May I please, Your Lordship? Your Lordship, I beg to mention item number 2.
Item number 3.
Item number 2, Your Lordship.
Yes.
In this, Your Lordship, we are yet to receive our parawise comments, Your Lordship. Therefore, Your Lordship, may kindly grant us 3 weeks time, Your Lordship.
What was this matter about?
This is a PIL regarding dumping of wastage, Your Lordship.
Dumping of?
Wastage dumping.
Wastage.
Yes.
My lord, this is I'm appearing for the PIL petitioners, my lord. So, my
Yes.
lord, there's a village called Ridi village, my lord. There's an open dumping happening, my lord, which we have carried out some investigation, my lord, by filing RTI. No statutory clearances, no permission was given. So accordingly, we have filed this PIL, my lord. So, my lord, if the state is asking for the time, I have no objections.
Okay. How much time do you need?
3 weeks time. But here's some request. He would be appearing on 30 or 28
20.
July.
28, my lord.
28 July.
Okay. Both sides are represented. P. Sangeeta, Learned Government Advocate, pays for 3 weeks for the time to file affidavit in the matter. Next para. The Learned Counsel for the petitioner has submitted that the respondent authorities have started dumping garbage in the area referred to in the PIL without any statutory clearances. In that view of the matter, the respondents are directed to file their affidavit positively by 22/7/2026. Next, list the matter on 28/7/2026.
My lord.
Next para, say that the Learned Government Advocate shall send a downloaded copy of this order to the concerned authorities to ensure filing of the affidavit by then, by the time allowed. List on so and so. Okay.
Much obliged.
My Lordship, I beg to mention item number 23. This matter will be listed after 2 weeks, my Lordship.
22.
Yes, 23.
23. Okay, you have taken consent?
Yes, my Lordship.
Okay, both sides are represented on the prayer made by Learned Government Advocate. List the matter on. Give a date after 2 weeks.
25 July, June. 20.
Lordship, in this matter, Honorable Justice Keita, since he was appearing as earlier, so he would not be taking up. So therefore, a fixed date probably cannot be given at this point.
Okay, after 2 weeks. Okay.
Obliged.
My lord, I beg to mention item number 21 and 22, my lord. My lord, the order which is the subject matter of this writ appeal was passed by the presiding officer, by one of the sitting presiding officer, my lord. This writ appeal.
Okay, by me.
Yes, my lord.
Okay. 21, 22. List the matter before any other bench without one of us. K. R. Solana Ji. Okay.
Much obliged.
My lord, item number 3, there is a technical error in the petition. So allow me to file afresh. Item number 3, Arunachal University of Study.
Item 3.
So
Your name?
My name is Abhay Dutt Verma, AD Verma.
You're not there in this matter. You're appearing on behalf of whom?
For the appellant. For the appellant, Arunachal University.
Your name is not there in the cause list. You have filed your wakalatnama.
My lord, my colleague has filed wakalatnama, that is Tito Taba.
Tell me the name of the council.
Tito Taba.
Huh?
Tito Taba.
Okay. Mr.
AD Verma.
ND Verma, Learned counsel appearing on behalf of Mr. T. Taba, learned counsel for the petitioner, submits that there are technical error in the appeal. So accordingly, it pays for liberty to withdraw the appeal and to approach again.
My lords.
Okay, prayer is allowed. Matter stands dismissed on withdrawal with liberty as prayed for. Okay, you are there, Mr. Ratan, as additional Advocate General.
For the state respondents.
Okay, Mr. N. Ratan, additional Advocate General for the state is present.
Item number 1.
There. Huh? Yeah. No, no. Over.
Is your PL not misconceived?
Yes, Your Lordship.
Is your PL not misconceived? After the orders of the Supreme Court, you can file your FIR anywhere and it will be sent automatically to the concerned police station. Your grievance is that there is a special police station only for corruption. So you think that you have to come here and file a complaint. This is nothing, no public interest is involved here. Has any police station refused to take your FIR and then send it to the appropriate authority?
Your Lordship, actually, leading counsel is out of station, so kindly matter may be fixed some other day, Your Lordship. I was not instructed to submit anything, Your Lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. Next para, on the next date of listing, the learned counsel for the petitioner would address the court as to what is the difficulty in filing an FIR with the jurisdictional police station. Because if the concerned police station does not have jurisdiction, it is required to send the FIR to the concerned police station. Next para, list after
2 weeks, Your Lordship.
2 weeks.
Much obliged.
We also do research on that.
Well, we have filed our affidavit. We have clearly stated that FIR can be lodged anywhere. It will be forward.
Okay.
Item number 4.
Right, please, Your Lordship. My Lord, item number 4 and 5, these are practically arising out of a common order passed in 2 miscellaneous applications that were filed by the appellant seeking modification, vacation of an interim order. Your Lordship may take up the writ appeal 35.
Have you agreed by this order?
My Lord, we are aggrieved because of the fact that, my Lord, we sought vacation of the interim order and we raised the question that there are disputed questions involved in the writ petition for which it's an election dispute, plainly.
Yes.
So writ petition may not be entertained. That was our plea. And our contention was also that in case we are required to disclose our stand on the merit of the writ petition, then tomorrow we may get prejudice, because if Your Lordship holds that because of the disputed questions, the matter needs to be referred to trial court, in that case, our defense will be foreclosed.
Why?
Sir, here, my Lord, here, my Lord, the writ petitioners, they have challenged a purely election dispute of.
We understand, but you see, when we remand the matter or send back the matter to the or delegate the parties to the appropriate court, any plea taken here would not be a residue judicata there.
No, my Lord, I am not on that, my Lord, but since there are questions of, my Lord, serious disputes are raised, my Lord, in the writ petition. Now, if we take our stand very clear here on the merit, my lord, then in the trial, my lord, we may get prejudiced. As for instance, my lord, I may say they have taken a stand in the writ petition that the very appointment of the election officer was not there. It is a fraud. Now, if we justify this statement, our defense here, my lord, tomorrow in the trial we may get prejudiced because our defense will be foreclosed. They have also taken a stand that the election officer did not publish the notification of election. They also take a stand that the entire election was conducted in a fraud manner in a particular house of a particular person instead of the election officer there being present. Well, these are the factual aspects, my lord, which they have agitated in the writ petition. And if we disclose our stand in these respects, my lord, in the trial we will be prejudiced because our right of cross-examination will be, my lord, in a jeopardy. So that is the reason, my lord, we wanted that let the question of stay and maintainability is taken up by the writ court first, and then, my lord, if your lordships find that indeed your lordships should be entertaining the writ petition, then we may be required to disclose our defense. Because here is a case, my lord, they challenging the election process, my lord, they come to court by filing writ petition 63. Now, in writ petition 63, my lord, there is an order passed by this honorable court that any decision taken in pursuance of the election and the election itself will be subject to outcome of the result of the writ petition. That order, your lordship will kindly see.
Which page in which writ petition, writ appeal?
My lord, writ appeal 35, I am referring, your lordship, writ petition 35, writ appeal 35.
35, yes, page.
In the second flag, your lordship will find page 39. That is the first order passed by this honorable court. And a very reasoned order, I should say, my lord, because the grievances of the writ petitioners are also taken care of and the possibility of an interference and otherwise is also noticed therein. May I just read it out to your lordship, and I just point out to your lordship that this writ petition was filed before the election was held. Election was scheduled. Now, two facts, my lord, I would like to press before I read this order, my lord.
You see, before that, the BCCI case, the Supreme Court has said that the cricket involves the public interest and therefore it held there in that it would be maintainable.
No, my lord, I am not saying that writ per se will not be maintainable. But in the BCCI case, my lord, this honorable Supreme Court also said that, my lord, I have come with that judgment, my lord, also said that each and every aspect of the matter may not be maintainable under writ petition. Only if it is rendering a public duty, then it can come. Now, election essentially is an internal management of the association. It does not deal with any public function as such. It is simply as to who will become office bearer of the association and in what post. That is the matter. Anyway, my lord, before that, my lord, I am just making this submission. They came to the writ court challenging the election process, alleging very many illegalities in the process, and they relied on a particular decision of Honorable Bombay High Court, wherein, my lord, the Honorable Bombay High Court had stayed the election. And with that prayer, my lord, with also a prayer that election should be stayed, that they filed this writ petition 63. This order was passed at page 39. My lord, I'll just take your lordship to page 40. Last paragraph. What? Last paragraph. Considering, am I with your lordship, my lord?
Yes.
Considering the submissions of the learned counsel for the petitioners and prima facie the constitution of the Arunachal Cricket Association in respect of preparation of electoral roll as well as the appointment of electoral officer appears to have been not followed, it is hereby provided that the AGM election of the annual Arunachal Cricket Association proposed to be conducted on 24th of February shall be subject to outcome of this petition. And if the AGM election is conducted, the same be conducted in accordance with law. So every situation where, my lord, the election, the validity of the election process was having a challenge, my lord, that is taken care of in this particular order. Now, in this writ petition, your lordship has noticed that what was the challenge? They challenged the election process and they wanted some relief in the form of interim directions from the court that the election should not be held. Now that interim prayer is not granted to them. So what they do, my lord, they file a second writ petition almost on identical prayers. Your lordship will kindly see that in the other, I'll show that to your lordship in the other case, my lord. But here, my lord, in this particular brief, your lordship may notice the page. Yeah, order to the pakai gusto. 97 to asal pakai. Second to. BCCI content to kita nak ada hack. BCCI content dia. Ini kita apa? Kita. Now, in this particular brief, if your lordship will kindly come to page 71, now kindly see the prayers made. Now, in single writ petition, my lord, they seek all sorts of writ, quo warranto, mandamus, certiorari, all in one proceeding. My lord, there is one judgment of our honorable court, my lord, division bench, which says that certiorari and mandamus cannot be sought. Sorry, certiorari and quo warranto cannot be sought in one writ petition. There is one decision rendered by Justice Gyani, my lord, long time back. But I am not on that, my lord. What I am on, my lord, they fail to get some interim protection from the honorable court in terms of stay of the election process. Now, the second writ petition they file, reiterating the same prayer. And there they somehow succeed in getting one interim order to the extent that the result of the election shall remain suspended. Now, your lordship knows it very well, my lord. In the election jurisprudence, it has been a consistent approach of all the courts that in election cases, my lord, the results are not to be stayed. The latest case, your lordship knows of the Madras High Court, my lord, where the writ jurisdiction was exercised and the Honorable Supreme Court has stayed it. Now, BCCI case, as your lordship had referred, my lord, may I just read out one passage from this judgment? My lord, the judgment which my lord, the writ petitioners are relying on, that is reported in 2015 SCC, my lord, but the beginning of that case comes from, my lord, 2005 4 SCC 649. That is a 5-judge bench decision. Well, 2005 volume 4 SCC 649. Well, that it is the basic case, my lord, from which that 2015 and 17 judgments have come. Now, in this judgment, if your lord, my lord, I'll just read paragraph 259, 738 at page 738. Father, may I read it, my lord? Only because a body answers the description of a public authority, discharges public functions, public law functions, and has public duties, the same by itself would not lead to the conclusion that all its functions are public functions. They are not. Many duties in public law would not be public duties. As for example, duty to pay taxes By way of illustration, we may point out that whereas mandamus can issue directing a private body discharging public utility services in terms of a statute for supply of water and electrical energy, its other functions like flowing from a contract, etc., would not generally be amenable to judicial review. There are numerous decisions of this court where such a distinction between public law function and private law function has been drawn by this court. Then, my lord, the references are given, and page 739, para 264, your lordship may see next. (264). We clarify that this judgment is rendered on the facts of this case. It does not lay down a law that all national sports federations would be state. Amongst other federations, one of the important factors which has been taken note of in rendering the decision is the fact that the game of cricket has a special place in India. No other game attracts so much of attention or favor. Further, no other sport in India affords an opportunity to make a livelihood out of it. Of course, each case may have to be considered on its own merit, not only having regard to the public functions, but also the memorandum of association and the rules and regulations framed by it. Only because it is a state within the meaning of Article 12, the same by itself would not mean that a body is bound by rule of reservation as contains so-and-so of the so-and-so. In Ajit Singh 2, a state of Punjab, it has been held that Article so-and-so is an enabling provision and thus it is not mandatory. The state in its discretion may provide reservation or may not. Furthermore, only because a corporation or a society is a state, the same would not necessarily mean that all of its actions should be subject to judicial review. The court's jurisdiction in such matter is limited. Well, this is the foundation of the case, my lord, from which, my lord, the BCCI case later in 2015, my lord, the BCCI case developed. My submission is that, my lord, on this aspect, I do not say per se jurisdiction cannot be exercised. What I say is that, my lord, a dispute which is essentially an election dispute, and your lordship knows it very well, better than me, my lord, that the election disputes are always involving disputed questions of facts. No election dispute can be tried in a summary manner. So my submission is that, my lord, a dispute such as an election dispute should not normally be entertained in jurisdiction. But that is not the only ground, my lord, on which the application for vacating stay was filed. Application for vacating stay was filed also on the ground that there are, apart from the fact that there are couple of writ petitions pending, practically all situations are taken care of by this order of the WPC 63, the first order, wherein the Honorable Court had already expressed its opinion that any decision of the election will be subject to outcome of the writ petition. Now, what they have been doing succeedingly, they failed in getting any stay order from that Honorable Court. They moved a separate writ petition now. In the next writ appeal, your lordship will kindly see the prayer, my lord, their prayer. It's exactly identical. I'll just demonstrate it by reading it from the writ petition itself. Well, in the writ appeal 36, if your lordship will kindly take up the brief of writ appeal 36. You have to the put it. In the writ appeal 36, you will, just for a visual comparison, my lord, in the writ appeal 36, your lordship will kindly open the page number 81. And in the writ appeal 35, your lordship will kindly have the page number 71. Kindly have a visual comparison of the prayers made in both the writ petitions. These are exactly identical. And in essence, my lord, they are repeating the interim prayer which they failed to get in 63. Kindly see prayer number 1, 2, and 3, my lord. This is exactly identical. Only they have interpolated the words here and there a little bit. And on similar circumstance, similar facts, my lord, these writ petitions have been filed only with the motive of getting some interim order, which they have succeeded in getting. 63. No, my lord, 63 is not here before your lordship. 63, no interim protection was given to them. My lord, the order I have read out to your lordship, that is in page 39 in the writ appeal 35. In writ appeal 35, my lord, the order is at page 39. Every conceivable situation, my lord, emanating from a decision in an election process, that is taken care of in the page 39 order. Now, by repeating the writ petitions, number of writ petitions, and by repeating the prayers, my lord, you cannot get an order which you were not granted in the first point of time. My lord, the first is 63 of 2026. My lord, I have a copy of the writ petition. Can I, if your lordship? First was 63 of 2026. Second was 97 of 2026. From 97, my lord, there is the writ appeal number 36. And then, my lord, 118 of 2026, from which this writ appeal 35 has arisen. Now, my lord, may I just, subject to your lordship's permission, my lord, may I just show the nature of disputes they are raising in the petition? Right from the time with regard to the appointment of election officer and all, each and every stage, my lord, they have a dispute. Now, whether these matters can be gone into, or rather should be, your lordship would go into those aspects, go into those aspects in a writ proceeding. Your lordship may kindly turn to, in the writ appeal 35, your lordship may kindly turn to page 207. 207, my lord, is a pleading filed by them in response to my application for vacating stay. My lord, that was filed challenging the entire election process, right from the appointment of the election officer till the time of notifying the elections, because at that point of time the elections were yet to be held. So the prayers that they made before the writ court, my lord, was to stay the notifications of election and stay the election, interfere with the election process and stay the conduct of the election as such. The second was 93, my lord, sorry, 97, my lord. There they challenged the same kind of writ petition, like, my lord, the quo warranto and certiorari and all. Similar prayers were also made in 63. But the only difference they bring out here is that they challenge the decision of the election, declaration of result. Along with all the prayers which were made in 63, my lord, the additional prayer that they make here is declaration of result. And the third one is that, my lord, after this declaration of result was challenged in 97, my lord, the appellants, they passed certain orders, like, since the honorable court has stayed the declaration of result and the election of the elected body, the previously elected body will work as a stopgap arrangement. That was an order passed in the facts, and that was, along with all other prayer, my lord, that was also challenged in 118. From prayer 1 to 3, my lord, there is exactly identicality. Exactly identical prayer. Only difference is that, my lord, there is some order here and some order there. Those have been added in the subsequent writ petitions. Now, kindly see their kind of dispute, my lord, which they want to raise in the writ petition, and for which, my lord, they want an adjudication on merit. If you're My lord, may I place a copy of the writ petition 63 for your lordship's perusal? Yes, my lord, that is part of the brief, my lord. That, my lord, in the writ appeal 35, your lordship will find it at, it starts from page 40, 40, sorry, it starts from page, in the writ appeal annexure 1, that will be from page 30, 80. Yes, in the writ appeal 30, 30, yes, it will start from page 80. There are 2 pages before, my lord, these are indexes. Page 80 is the beginning, my lord, the rules and regulations.
Lordship, may I make a submission, Lordship? I'm appearing through BC, Lordship.
My lord, that will be 225. Lordship is requiring me to place the stay order. Oh, that is 225. Page 225, your Lordship will find the order, and the final part is at page 250. I am aggrieved practically by the penultimate last but one paragraph. This court is also of the opinion that considering the facts and circumstance, instead of deciding the IA, writ petitions as such would be required to be heard.
This would be that page 250.
Yes.
Has also said that the council will get liberty for upgraded. That is, the official very first right to 15
Yes.
56 is
Next Monday. But the difficulty is that, my lord, their parties are yet to be served. They are, except for us, my lord, we are only 2 parties before the writ court. There are altogether 8 or 9 respondents in the writ petition. They need to be served. Their affidavits have to come. Their rejoinder have to be completed. So it will not be possible for a hearing on 15th.
the amount of effort it takes for disposal of the IA. With the same effort, you can always dispose of the
My lord, my submission in the IA is very simple at this stage, my lord. Although, my lord, many things have been said. Since our grievance is only limited to the extent that the Honorable Writ Court should decide the IA first, instead of deciding the things together. Because if the decision has to be taken together, my lord, then it will be No, I'm not on maintainability per se, my lord. I am on the question of the continuation of the stay order. Because by this order, impugned in the appeal, my lord, the stay has been extended. And it will keep on getting extended, my lord, because the pleadings have to be completed if the writ petition is to be heard on merit. Without the pleadings being complete, my lord, writ petition cannot be taken up for disposal. And in that scenario, my lord, if the stay gets continued, it is we who are getting prejudiced. Kindly see, my lord, who are the writ petitioners? They did not contest the election. It is their stand in the writ petition that they did not contest the election. Now, even if the writ petition is allowed or if the stay is vacated, my lord, no rights of theirs is going to be prejudiced. Because ultimately, if your lordship decides that the writ petition itself is maintainable and writ petition should be allowed, there will be a fresh election. But in the process, my lord, it is our right which is getting infringed. No rights of theirs is affected. They did not contest the election. They did not participate. They say that we boycotted the election. We did not participate. That is their pleaded stand in the writ proceeding. So ultimately, my lord, in a question of stay, my lord, it is the balance of convenience and loss and injury that your lordship takes into account.
Then there will be a fresh. Because there will be a election then. Is it not? Supposing we accept the contention of the
Writ petitioner.
then what happens?
Then there has to be a fresh election.
Fresh election.
There has to be a fresh election. But for the reasons which I have stated in the application for vacating stay, my lord, if your lordship takes a decision that we will not entertain into this dispute, parties are relegated to the trial court to get the matter thrashed out there. Then what happens? In that situation also, I am prejudiced because I need to hear the matter on merit, my lord. I need to disclose my defense.
No, you are a public body. What is wrong in disclosing a defense twice?
My lord, your lordship, my lord,
They are challenging it because they say that the office bearers who called the election, where functus officio, their term had already lapsed.
My lord, with all greatest respect, my lord, I will say the concept of functus officio is not applicable to a private body. Functus officio is applicable only to quasi judicial. There is a judgment also of Supreme Court on this point, my lord. I will just need 10 minutes time to produce it. Very latest judgment authored by Honorable Sandeep Mehta. Well, functus officio is supposing a judge or an arbitrator passes a judgment, thereafter they become, it renders a statutory authority, renders a decision, they become functus officio. Well, in respect of public body, sorry, private body, this concept cannot be imported.
No, they have a reason. They say that the term was over, and therefore once the term was over, they could not have called for the elections.
No, elections were called. Elections were called, results were declared.
That's
When
why they are challenging it. They say that you could not have the authority to do it.
no, they are not saying that we do not have authority to call the election.
Yes, that is there.
No, my lord. My lord, I need to then clarify the point, my lord. Your lordship will kindly see their kind of grievance in the writ petition. They don't say that the election cannot be convened. They say that the election was not to be held in this manner because there were violations of certain rules. And what were those? Those were regarding appointment of the election officer, notifying the election schedule, and consequently holding the election in a free and fair manner. Kindly see they are pleading in the writ petition. Well, the writ petition is also part of the appeal brief.
You see, page 59, that is what is there.
Page?
Page 59, paragraph 2, that is how they structure it. The tenure of the previous executive committee was strictly mandated for 3 years. This tenure concluded prior to commencement of the election process on February 26. Upon completion of the 3-year term, the mandate granted by the general body stood automatically extinguished. Consequently, they become functus officio, losing all legal standing, and therefore any continued exercise of power beyond this term is direct violation of democratic principles and Lodha committee reforms. This is how they structure it.
Now, if it is the case, if it is to be understood to be correct, my lord, then who will call the election?
We don't
It-
know.
No, my lord, then this answer also has to come. If you say that,
No,
my
that
lord,
answer will come only when we write an order, when we use that.
no, my lord, no, this answer has to come from them. Because it is an election of an FX body. It is always called by the body itself. Your lordship will kindly see the regulations, my lord. Their grievance is very specifically noted by the honorable court. My lord, many things are pleaded in the writ petition for the purpose of making a plea. But ultimately, my lord, it is what your lordship takes into account and passes an order on. That will matter, my lord. In the order which the honorable court has passed, the page 39 is very specific regarding their case. I'll just read it once again, my lord. The second paragraph, page 39. By filing this
Just a moment, just a moment.
This is the ambit of their writ petition, my lord. The honorable court has noticed it.
Right.
63, there is no interim order, only saying that it will be subject to outcome of the writ petition. The election will be subject to outcome of the writ petition. So everything is taken care of. Well, so my submission is that, my lord, it is a settled proposition through a long line of decision that in election jurisprudence there cannot be stay of election, and that jurisprudence is reflected through the order of the Honorable Court at page 39. The order of the Honorable Court at page 39 reflects this jurisprudence. It is in acknowledgement of that proposition that there cannot be any stay of election process in a writ petition. It has to be challenged through an appropriate proceeding. Since there is no ombudsman, they are complaining that there is a mechanism in the regulation, but for resolving the dispute through an ombudsman, they are complaining that there is no ombudsman, therefore they cannot go before it. Well, the trial court is there. And even if they take recourse to the ombudsman, my lord, it is only a matter of appointment. Your lordship, today your lordship appoints somebody as ombudsman, my lord, the end of the matter. I am only on the question that whether by bringing an embargo like this, my lord, they can stall the functioning of the association. And what they have done in the subsequent petition, my lord, your lordship will kindly see page 122, page 122 of this writ appeal 35. This is the interim arrangement that we make. They even have a complaint on it.
Just a moment.
And they have to demonstrate a case that how grant or refusal of this stay order will prejudice their case.
Have you annexed a copy of WPC 97?
Yes, my lord, it is there.
Which page?
My lord, page 97, your lordship will find it. No. In writ appeal 36, your lordship will find the 97. And writ appeal 36, my lord, it will be at page 39. Look, yeah, my lord, I was just referring to page 122 in writ appeal 35. This was, my lord, a stopgap arrangement made after the results were stayed in writ petition 97. Now, challenging this, they filed a second writ petition. Third writ petition, saying that even this cannot be made. Well, it's a complete stranger to the body who did not contest the election. My lord, how at their instance, my lord, this can be done? First of all, they have to show a prejudice being caused to them, my lord, in order to sustain the interim order in their favor. And therefore, my lord, in other writ petitions also, your lordship will notice, it was not a blanket order of stay. It was only till the returnable date. And the Honorable Court made it clear that we can very well come with the application for vacation and modification. Your lordship will just see that order, my lord. Page 43. In writ appeal 35, your lordship will kindly see page 43. That is the second order whose vacation we are asking for in the present appeal.
Page 40?
43, your lordship will read page 45 straight away. The last paragraph, last but one. Since an interim order has been passed without hearing the respondents, they will be at liberty to seek modification or alteration of the interim order. And that is how we file the application for vacating stay. Page 45. And thereafter, we file the application for vacating stay. Now, without hearing the application for vacating stay, my lord, if it is unilaterally extended, my lord, then it is we who are at loss. The writ petitioners are at no loss. They did not contest the election. They are stark strangers to the process.
But they are your constituent.
Yes, they are our constituent. So if they want a fresh election, my lord, maximum that they can get in the writ petition is an election.
Okay, we'll hear the other side. If you have any citations, please give the list.
Yes, my lord, that I'll give, my lord. Your lordship may give me 2 more minutes, my lord. I just want to show 2 more things, my lord. Huh? Your lordship will kindly see page 122 in writ appeal 35. Hmm.
Yes.
Page 122 is the stopgap arrangement, my lord. My lord has seen the page 43 order, my lord. Page 43 order is the order by which, my lord, the election was stayed, giving us the liberty to come to honorable court, seeking modification and alteration, etc. Now, after this order was passed, we pass or some order at page 122. That in the interregnum, till the time some remedial process is undertaken, in the interregnum, a stopgap arrangement is made. Now, an association makes a stopgap arrangement to manage the current pending affairs. How you are aggrieved thereby? You have, what is the right of the writ petitioner? Their maximum right is to cast their vote, nothing else, nothing more. And they have a right to, since they have a right to cast vote, they also have a right to contest. Now, you did not contest in the election. Your lordship knows, my lord, even in the Representation of the People's Act, election petition can be sustained only on 4 or 5 eventualities prescribed therein. The conclusion is that the result of the election would have been materially changed if the illegalities were not there.
That
Now-
principle stricto sensu would not apply here.
Understood, my lord. That's a special statute for a special situation. Understood. But the principle is common. The principle is that it's a democratically elected body and you did not cast your vote. You are all right. You may have some merit in your contention that there were some illegalities, some irregularities. For that matter, the maximum that you can get is a fresh election. And the fresh election will be subject to outcome of the writ petition. Not otherwise. How in the interregnum you stall the functioning of a democratically elected body? And by stalling the functioning of the elected body, what right of yours is protected? Well, your lordship grants an interim protection to protect certain rights of
It's
the...
a universal phenomenon. We are not aggrieved by our failure to do something. I'll be more aggrieved if I find success in you. It's a usual phenomenon. I'm not aggrieved by my own fallacies or shortcomings.
No, well, ultimately, balance of convenience.
When I'm driving a Maruti 400, I'm more aggrieved if what you call a higher standard vehicle passes by.
Well, but that cannot be construed to be an injunction that nobody can buy the higher standard vehicle merely because I cannot afford it, my lord. Nobody can ask the court to completely ban purchase of higher standard vehicle. That cannot be a case. My lord, therefore, my lord, my respectful submission is that, of course, my lord, I'll have a right to respond to my learned friend's submissions.
If you have any suggestions, please give it.
Yes.
Yes.
Oh.
You are appearing for whom you are appearing for?
Respondent
petitioners.
number, I'll be appearing for respondent number 1 to 6, Lordship.
1 to 6. Yes.
Lordship. Lordship, since the copy has not been served upon us, Lordship, since we are the writ petitioners in all those writ petitions pending before the single bench, since this is a intra-court appeal, Lordship, they ought to have served us a copy. They have not served.
No, my
So
lord,
I'll
there
not be in
is no
position to-
caveat. There is no caveat, my lord.
Now he has appeared, he seeks a copy, we'll have to give.
No, if he asks for, my lord, then we subform it. But there is no requirement that you should give them an advance copy. We give advance copy only if there is a caveat.
So I humbly pray that a copy may be served upon us, Lordship.
You see, under Order 3, Rule 4, the mandate of a lawyer continues in appeal.
Well, that is
That principle is inherent in the High Court rules also. Therefore, once he appears and then they can't prevent him from.
no, my lord, if he appears, my lord, I don't
Give
want.
him a copy, we'll take it up day after tomorrow.
All right, my lord. We give copy, my lord, within this the course of this day, my lord. Your lordship will kindly take it up. day after.
Otherwise, also that IA that they have filed, it is active in consideration before the single bench, Lordship. On what ground they are
Either you
exhibiting?
argue on merit, or then you take a copy and then argue day after tomorrow.
All
If
right,
you are
all right.
prepared to argue today, we are ready to hear it.
Lordship, I'll obtain the copy, Lordship, and then we'll argue, Lordship.
Okay, you give your, send somebody to, so that somebody will collect it. You will
Lordship,
collect it for.
my associate
Okay.
friend is there.
Okay. You see, for this as the Senior Council assisted by Mr. H.K. Nath, Learned Counsel for the appellants. Mr.
J. Gini, Lordship.
J. Gini, Learned Counsel, and enters appearance for the respondent numbers 1 to 6 and prays for a copy of the memo of appeal. Let a copy of the memo of appeal be provided to the Learned Counsel appearing for the respondent number 1 to 6 in course of the day. List on day after tomorrow.
11-6.
Obliged, Lordship.
Item number 6.
4 or 5 separate orders per same.
Well, 4 and 5 are together. Lordship.
We are passing separate orders. We are not passing a common order. Yes, item 6.
May I please, Your Lordship? I am appellant, so I have received the copy of affidavit from the respondent. So I need some time to, I am filing a rejoinder, my lord. I may be allowed some time for filing a rejoinder.
Just a moment.
No, my lord, we will not file, my lord, because IMC had filed, my lord. Respondent number 3, 4, and 5 is filed.
Affidavit filed by the respondent number 3, 4, and 6,
Six,
my
my
lord.
lord. There's standing counsel, my lord. There is standing counsel for IMC, my lord. Not here today.
Three, 4, and 6, you have seen that
Yes,
affidavit?
yes, madam.
You have it with you?
Yes, madam.
Can you come to page 125?
My lord, 125.
125. Annexure 1, photograph. Now, according to you, which photograph gives you confidence that this construction was done in 2020? Finance Commission, if I am not wrong,
Yes,
14th Finance Commission period will be from 2015 to 2020. Correct.
Yes, ma'am. 5 years, yes.
So in the affidavit, there is no date of completion. They've given us photographs.
Only photograph, my lord.
Correct.
Yes, my lord.
None of the photographs. We have seen the photographs. From the photographs are appended here for the entire the rest of the pages. Please show us one photograph which gives you confidence that the work is complete in all respect. One photograph out of this, perhaps 50 to 100 photographs annexed.
Yes, my
Show us one photograph which gives you a confidence that this work was completed.
here, my lord, come to page 156, my lord.
156.
There's some photograph, my lord. And in the bottom side, my lord, it's written complete, my lord. Maybe this work was completed, my lord.
This is how you
156.
say a completed work.
Yes, my lord. Maybe, my lord, because it's written
No.
complete.
This is a borewell,
Yes, my lord.
correct?
Yes.
Now, look at the borewell and look at the ground. This is how borewell is maintained?
Actually, mine is in black and white, my lord, so I can't see,
No,
my lord.
it's black and white here also. Have you seen a borewell any time? You had an occasion to see a borewell.
Yes, my lord. I've
Is
seen.
borewell maintained like this?
Maybe, my lord, IMC will be answer, my lord.
Hmm?
IMC will answer, my lord, the standing council, my lord, who have
No, we
filed this
understand.
affidavit, my lord.
But if this is not,
Because, my lord, in page number 164 also, my lord, in the last page complete, there's completion certificate, my lord.
you see, come to page 157. This is just I was to create a work done and then end it because the debris are still lying here. And if it's a old work, the debris will not lie like that. This is an unkept debris which shows a very recent construction. Now come to page 150. Any damn page you want to look into. Correct.
Yes, my lord.
Page 161, for example, freshly painted staircase. Even the paint is oozing. Correct. Page 162. Page 163.
In page
What is
162,
completed?
my
Don't
lord,
know.
in page 162, my lord, during work start, there's three, my lord, three photograph, my lord.
Ah, yes.
And after complete, my lord, it's different.
Nothing is complete here. They wanted to take a photograph and then the end of the matter. They take photograph, do some plaster, take photograph, end of the matter.
But, my lord, there's completion
Page
certificate, my lord.
173.
Physical progress 100%, financial progress 100%, man. It's complete, my lord, according to this affidavit and photograph, my lord.
This is your state.
That's true, my lord.
If you are happy with this sort of work, then we can only hope that you will remain happy. I would not even like to go there and look at this. Not even for a moment. We would like to go there and see this work.
Then, my lord, I will be given time, my lord. I will take instruction, my lord.
This affidavit doesn't say anything. When
Yes,
it was completed.
Then, my
what
lord,
is the
I will
date of
file
the
my
work?
affidavit,
There's
my lord.
nothing. Council is not there. You're the council.
My lord,
Correspondent 3, 4 and
my lord, I have been
3,
newly,
4 and 6.
my lord, just now I only see in the cause list. I
You're
have been,
rejecting your affidavit.
my lord, I have
Yes.
been newly appointed as, my lord, standing council, IMC. But my lord, a brief has not been furnished to me, my lord. I have been not instructed by the authority, my lord, IMC yet in this matter, my lord. So, my lord, I have no idea about this matter, my lord.
We are putting you to notice why this affidavit should not be rejected.
My lord.
Mr. UC Dekar and counsel for the petitioner, Ms. P. Sangeeta, sorry, Ms. T. Wangwo, and government advocate appearing for. Your designation is,
1, 2, and 5, my lord.
your designation would be,
Come advocate, my lord.
your government advocate for respondent numbers
1, 2, and 5.
1, 2, and 5. And Mr.
My lord, El Kurdu, my lord.
S.
El Kurdu, my lord, El Kurdu.
Just write it down.
El Kurdu, my lord.
Just write it down. Done council
Standing
who
council, my lord.
appears for respondent numbers 3, 4, and 6 and has submitted that he does not have the brief and he has been instructed to appear in the matter. Next paragraph. The photographs appended to the affidavit in opposition appears to be a photo shoot only for the purpose of this affidavit. And the affidavit does not indicate the date on which the particular works for which photographs are annexed were respectively completed. None of the photographs contain the date on which the photographs were authenticated by the concerned executive engineer. Of the Itanagar Municipal Corporation. And the photographs also do not indicate the geotag data or the dates on which the photographs were taken. Therefore, the court is inclined to put the respondent numbers 3, 4, and 6 to notice as to why their affidavit filed without material particular should not be rejected. Next one. The learned counsel for the petitioner prays for and is granted liberty to file affidavit in replying the matter. List your date after two. It should go after vacation. We will not have time to take it up. Due date after vacations. List on so.
21 July.
You better send this downloaded copy of this order to the respondents. Before that, you said last line. The learned counsel appearing for respondent numbers 3, 4, and 6 shall send a downloaded copy of this order to the Itanagar Municipal Corporation to so as to put them to notice of the order. List on so and so.
Obliged.
Obliged.
Item number 7.
Yes.
Mala, in this matter, Mala, pleading is complete, Mala. The last respondent Rasmanov 3 has filed affidavit on 12/5/2026. Now, my lord, the matter can be listed for admission hearing. After
Lord, I may be served with a copy of the.
You are challenging the order of the National Green Tribunal here.
no, my lord.
Then why is this annexed here?
My lord, challenge here is my lord, the non-compliance of Arunachal Pradesh stone crusher guidelines of 2012, my lord.
Okay.
Yes, my lord.
Lord, this may be fixed for hearing, my lord. Because I've just received the affidavit. I've just received the copy of the.
Okay. All sides are duly represented. It is submitted at the bar that the pleadings have been exchanged and the matter is ready for hearing. So accordingly, list the matter for hearing on. Give a date.
After 3 weeks.
After vacation, it goes. Give a date.
23 July. Item number 8 and 9.
Okay. Disconnected actually. Yes, next item.
Yes. Item number 10 and 11.
Item number 10 also same applicant out of said incident.
For appellate in 11, item 11, contact person, amicus curiae.
Okay, I've said all sides are represented.
Declare.
Item number 12.
Your Lordship, I mean item number 12, 14 and 15. This is three cases are arising out of common judgment and order. Jail appeal, this is a jail appeal. And yes,
Awaiting preparation of a paper book. Then item number 13.
14 and 15.
This is 12.
Yes.
13. 13.
12.
Okay.
12, 14, 15.
12, 14. And item 14. The legal aid counsel is D. Johnny.
Yes.
Is he available now?
He's also not seen today. Conviction was under 364 capital A, 365/34 common institution.
Yes, sir. What is it? D. Johnny. Okay. The legal aid counsel, Mr. D, legal aid counsel, Mr. D. Johnny is absent on call. So how about Mr. Tarul, additional PP is present. Next para. Separate order has already been passed in criminal appeal jail 19 AP of 2025. Stop. The paper book of this connected matter will be also prepared and handed over to the London Legal Aid Council in the London APP. Next para, list after 4 weeks awaiting preparation of the paper book. Then item 21, you are there.
15.
15, I'm.
Oh, 15.
15, Lordship. Lordship, here, Lordship, I need some more time to file appeal memo and condonation of delay, Lordship.
You have Mr. T.
G. Gini, Lordship.
G. Gini. Okay, heard Mr. G. Gini, London Legal Aid Council. And Mr. Tarul, London APP for the state. Next for the London Council for the London Legal Aid Council pays for some time to file an appropriate memo appeal. So prayer is allowed. Next, in the meantime, the paper book be prepared and the same be handed over to the London Legal Aid Council and to the London APP for the state. Especially after 4 weeks awaiting filing of the formal memo appeal and preparation of paper book.
Highly obliged.
Item number 13.
Yes. What about respondent number 2?
Service not completed yet, Lordship. It's yet to complete service upon respondent number 2.
But the steps has been taken long back.
Yes, Lordship, through our PP office, Lordship.
This was issued through the
PP office.
Respondent 2 to be served through the officer in charge of Namsai Police Station. This was sent in 6/9/2025. You
Again,
sent a
Lordship,
deputy message to the
uh,
Namsai police station as to what has happened.
Lordship, again from our PP office, Lordship, we have served the notice, Lordship, on 8th September, Lordship.
Notice, sir.
Yes, Lordship.
So this is steps you have taken, but the
Yes,
service
Lordship.
is not there.
Lordship, yes, Lordship, upon respondent number 2, Lordship, victim, Lordship, we have given service of notice, Lordship, through our PP office.
We understand, but where is the service report?
Lordship, they have not, Lordship.
That's why,
received, Lordship.
that's
Yes,
what we
Lordship.
are worried about.
Yes, Lordship.
Because through PP office also you will send to the jurisdictional police station.
Yes, Lordship.
So they are not responding to it.
Not, Lordship, not yet, Lordship.
We'll ask the SP, Namsai police station is under which district? District Namsai.
Lordship,
We direct the SP to follow it up and then send a report.
yes, Lordship. That order may be passed, Lordship.
Your name?
M. Jarang, Meenakshi Jarang.
Ms. M. Jana, under counsel for the appellant. Next, as per office note dated 6/9/2025, steps was taken for service of notice on respondent number 2 on 5/9/2025 through the Office of the Public Prosecutor to be served through the officer in charge of Namsai Police Station. So the process was sent by memo number 2220 dated 6/9/2025 by registered post with AD. And so
Data ko naam to give le service le meri. Data ko naam to give no hai. No hai. Data ko naam. Address to be sir.
post off. A copy of the notice was also handed over to the Office of the Public Prosecutor. Post off. Next, the learned public prosecutor has produced a copy of steps taken on 8/9/2025. To the officer in charge of Namsai Police Station for service of notice on respondent number 2. How this was dispatched?
Lordship, through Lordship, speed post, Lordship. Otherwise, through email also we have, Lordship, sent, Lordship. Through email also we sent, Lordship.
No, but you create a system because otherwise
Lordship.
it will be very difficult. You shouldn't be sending it through email. You should be sending it through the, by using the police communication.
Lordship. Lordship, we through Lordship, here Lordship, we
No, then we'll have pass a judicial order to the police administration and the home to have an interaction with the, with our registrar. So to create a system where you can transmit these notices to the police stations. If you start sending it by speed post, then it will never reach.
Lordship, through Lordship, PS only, Lordship, we send, Lordship. Here, Lordship.
They'll have to create a system and give it to you.
Yes, Lordship.
The public prosecutor should give it to the nearest nearest police station. It will be the duty of the police station to send it through the radio, Arunachal Pradesh radio organization, and then transmit it to the concerned police stations. Or if they are using an email, they'll have to tell you and give us also the addresses of all the emails of all the police stations. Otherwise,
The email lordship, they provide lordship through email also we send lordship.
no, but in this case, you'll have to show us how do you send it. Otherwise, we direct the Director General of Police to send the officer to the registry and to have a joint meeting with the registry and the public officer on the public prosecutor to create an ecosystem to transmit notices. Most of how after service the notice has not yet been returned. Full stop. Next, in the considered opinion of the court, as there is a legal requirement to the victims of victims of offences under the POCSO Act to be served with a notice of an appeal or any other application which is filed by the accused person, the state respondents through the establishment of the Office of the Director General of Police, Arunachal Pradesh, are required to create an appropriate system by which the notices which are required to be served on the informant, the victim, is handed over to by the Office of the Public Prosecutor at Guwahati High Court, Itanagar Permanent Bench, to the nearest police station to be served through an appropriate police channel, and or to provide the email addresses of all the police stations to the Office of the Public Prosecutor, through which the scanned copies of the notice and the applications can be sent to the jurisdictional police station for online service, for physical service to the accused of the informant. Next, accordingly, the court is inclined to direct the Director General of Police, State of Arunachal Pradesh, to call for a joint meeting of the representatives of the registry of this court, the public prosecutor, as well as an officer not below the rank of police officer not below the rank of
SI lordship.
No. Meetings will be by the additional DGP or something like that.
Oh, lordship, for meeting lordship, then lordship, DSP lordship.
Huh?
DSP lordship.
DSP is too low.
And then
DSP
SP.
will go to the rank of SP. You
Lordship.
can direct the SP also. So it will not be less than additional DGP.
Lordship, here.
Otherwise, the administration will not run.
Yes, lordship.
Your DSP statement will not be taken by an SP.
DIG lordship then.
DIG.
Lordship.
Okay. Not with the rank of Deputy Inspector General of Police. So as to create a channel for service of notices to informants or victims of offences under POCSO Act. through the which is required to be served through the jurisdictional police station. Next paragraph.
Item number 17 and 18.
May please also. Am I?
Yes. Yes.
Audible, my lord.
Yes. Mr. Dolo, your matter has been called.
That is 19, my
Hmm?
lord.
Yes,
19.
Item number 19.
This is 19. My lord, I heard 18, my lord. This matter relates to my lord land acquisition. Actually, what happened, my lord, in the area of Tawang and Bumla, and army has occupied some of the land. Then after that, my lord, it is in 9 pockets. Then no compensation was paid, no rent was paid, and then it was not acquired. Then the affected person, they have filed a writ petition. And after the writ petition, it is directed that the land may be acquired. And after that, what happened, my lord, the Ministry of Defense, as well as the all Ministry of Defense, they conducted the survey. There's later part. And in the survey, along with the petition, it is found that out of the direction has been given in a single court, this is 3,333 acres. But actually, when the survey was done, in present of the petition, it is found as 556 acres only. So after that, what happened? The Ministry of Finance, the Ministry of Defense, and the Ministry of Law and Justice, the department is seeking the clarification regarding what is to be done. Then what happened? They had given their legal opinion, and when they found that 536 acres only, they directed to prefer the reappeal. And reappeal has been filed, but today the matter has come for condonation of delay. For condonation of delay, that is, my lord, 541 days. And in my condonation of delay petition, it is day by day, which is why weeks by month by, but all clarification has been given. And how this delay was.
Where is the order?
That is in order is in writ appeal or in the stay application. In page 117, my lord. 117, impugned order is 117 of memo of appeal, my lord. Annex of 4. The affected operative portion is in page 125. My lord, has your lordship got it?
No, but this is a order. The appeal would not be maintainable. You gave a consent that you had no objection to the land being acquired.
No, my lord. Land is acquired, but thing is, land actually that will decide. And in paragraph 10 of the Honorable Single Judgment, they said after receiving an in principle approval. In principle approval is a very big thing, my lord. Then what happened? Army, that defense state, all of them, they have to sit together. Then they have to take a decision. Then decision to be carried on Ministry of Defense. Then Ministry of Defense will give to the Ministry of Finance. Then after the sanction will come, my lord. So in the order it is says, my lord. state that with direction to the Deputy Commissioner of Tawan District to initiate the formal process of acquisition of land, subject to receiving in principle approval.
No, that is your own affidavit. In your own affidavit, you have
Yes,
said
yes,
so.
yes, my lord. In
This is-
principle, approval, in principle, approval is a matter, this is not a very simple thing. The lot of formalities to be done.
No, that is okay, but it is your case that in principle will give.
No, in principle, approval so far that has not been sanctioned, my lord. Only the army cannot give it. For the defense state has to also sit, the army has to also sit. Then after that, what happened, they will consider the matter. Then what it will go to the.
No, that's not the issue. The point is that in paragraph 4 and onwards, you say that the in principle approval is first required.
Yes.
So therefore, the court has given that direction in.
Yes, my lord.
In this that to initiate formal process of acquiring and in principle approval.
Yes, in principle approval means that is allowing to do the survey. After the survey, when the report will go, then ministry will get the sanction, and from the President of India, from the concurrence of the finance department, sanction will come. That is only the preliminary stage for the in principle approval, my lord. But and basic fundamental thing is that, my lord, this is the entire land is, my lord, there 3,300 something acres. Actual occupation is 500 and something acres. It was found out after the judgment only the joint survey was done. That time petitioner was also there. Prior to that also, my lord, the proper scaling, all this survey was done. Now this thing is, today the matter has come.
No, but 541 days, we are not even inclined to issue notice.
No. 541 days, you have been narrating everything, my lord. Because in the Supreme Court, that's judgments I will produce before your lordship. Then your lordship may turn to my interlocutory application, page 118.
You see, first of all, there is nothing in your affidavit to deny that you are in possession of 1,300 odd hectare of land.
Your lordship may come to page 118. This is
page 118.
118 of my IA. (562 acres).
Yes.
5, madam, paragraph 5. The department or the presence of the references submitted that with regard to the verification process of the mention in the DSGI, it is intimated that the Army Authority has constituted board officers for carrying out a joint survey and assessment of the area under operational occupation of the formalities unit with reference to the writ petition number 312/2023. Accordingly, the joint survey of the Shar Tasu community land under the operational use of the army has been carried out, and all stakeholders, including the petitioners, and they found that the total area measuring 562.486 acres in location under the operational occupation of the army, which is much less than the area mentioned in the Honorable High Courts at 1,370 acres, that is 3,384.34 acres. By para number so and so, so and so, so and so.
Now, Mr. Dole, come to page 95 of the memo appeal.
Yes, my lord.
Paragraph 11. There is no specific denial. 1,300, we take note of 1,300.
My lord, what happened, my lord, when this affidavit opposition was filed, there may be, that time, what time defense state was also not in a sure, actually, my lord. So that is why we want to find out the detail. We don't want to deprive the those who are in owners of the land. But this figure is exorbitant, my lord. Then where is, suppose the government of India has sanctioned this amount, where money will go? Because they have 565 acres only occupied, my lord. That also government of India will decide whether that will be taken on lease or acquired, because this is in Indo-China border, my lord. That time, strategical reasons, they sense the strategy also. So how much land will be required, how much it will be acquired, that will decide by the Ministry of Defense, my lord. And now it is found that after the proper survey, the 2-time survey, my lord, that is only 536 acres, my lord, not 3,300 acres. It's a huge amount of land. And that is in the 9 pockets.
1370 hectare.
Yes, yes, my lord.
And in acres it is 3384.
Yeah, acres, yes, my lord.
Now you say it is 562.
562 acres, my lord. $556 acres. That is under occupation. My humble submission before Lordship is that the matter may be disposed of with merits, my lord. Because what happened in the repetition, I think it was not apprised before our Honorable Single Judge that actually the figures. So let the writ appeal come. Actually, if it is in the actual possession, if the Ministry of Defense, they want it, definitely they will pay and pay the compensation as part of 2013 Act. Yes, yes, my lord, something that can happen. That is the happen after that when the matter goes to the Ministry of Defense and Ministry of Law of Justice, then they scrutinize it, they have found it out. And survey, my lord, in 1 year, that 14,000 feet, my lord. 14, not in a plain area. That is in Tawang, in Bumla, in between China and India. That's a very difficult terrain.
As a defense organization, they are a state officer. What do they do? They do not have the idea of what land they are having.
My,
How do they maintain the land? They don't have the area.
my lord, actually procedure is very clear. Just 1 second, my lord. Actually, regarding that thing, my experience with the Union of India, sometimes it is practically what happens. So after the Chinese aggression, suddenly army occupies the land. Without any authority, without the proper estimate. Actually, they don't have that authority. Army, they don't have the authority. There is an act for that, my lord. That is 1944 ACR rules. Defense state is the only authority if somebody wants a land or sky or water in the sea or sky or the land, they defenses has to approach. Then earlier, 5-6 years back or 10 years back, I have seen suddenly army occupies the land, they want the land, and there's this thing. And then after that, one Ministry of Defense given a strict, 2010, they have given a strict order. No army can acquire means take a loan without the permission of the defense state. Now things are regulating after 2010, after that notification. It was happened because ACR rule 1944 was not followed. That happened, my lord.
Learned CEC appearing for the
Union of India.
Applicants.
Yes, applicants.
Land management will be there.
I'll be appearing.
Hmm?
4.
You'll be appearing.
Yes, ma'am.
And is it T. Wangul and the government advocate appearing for respondent numbers 11,
12 and 13.
12, and 13. Someone will appear for 14 to
Yes, Lord.
16.
Yes, Lord.
You will be there.
Yes, Lord.
Miss,
Vaika on behalf of M. Kata, Lordship.
on behalf of MCATO, CGC, learned DSGI for respondent numbers 14 to 16. Next, madam. The learned CGC appearing for the applicants have submitted that the Indian Army was in possession of a plot of land which is in the vicinity to the Indo-China border. Full stop. The principal respondent numbers 1 to 10 had projected in the writ petition that the army was occupying 1370 hectares of land which is land. It is submitted that the said 1370 hectares would be approximately 3384.34 acres, approximately. Full stop. Accordingly, on the basis of submissions made by the learned DSGI for the Union of India and the learned Standing Council for the Land Management Department, the learned government advocate and the learned counsel for the petitioners, the learned single judge by the impugned order 6/11/2024, passed in WBC 312 of 2023, disposed of the writ petition by directing the Deputy Commissioner, Tawang District, to initiate the formal process of acquisition of land, subject to receiving in principle approval of the Ministry of Defence. And in that regard, it was directed that the State Defence Officer of the Indian Army Authority will also send a requisition letter for obtaining in principle approval from the Ministry of Defense. And after all necessary formalities, the Deputy Commissioner will take initiative for acquisition of the land and provide adequate compensation to the principal respondents under the as per the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013. So this, by reference to the stand taken in this interrogatory application, it is submitted that the Army authorities had constituted a board of officers and conducted a joint survey of the area under occupation
On 21/4/2025.
on 21/4/2025.
2025.
And in the presence of the stakeholders, including the principal respondents, respondent numbers 1 to 10, it was found that the total area measuring 562.486
Yes.
acres in 9 locations were found to be under operational occupation of the Army. And not 1370 hectares within bracket, approximately 3384.34 acres, bracket close. Stop. Next, accordingly, it is submitted that the area under occupation is far less than what was projected before the writ court. Next. It is submitted that the applicants have provided the details of the time spent in preparing the connected appeal. Next, issue notice returnable on so-and-so. Due date after 5 weeks.
10th of July is not
The-
convenient for your lordship.
Applicants shall
10th of July
take
is
steps
holiday.
within 2 days for service of notice on the respondent numbers 1 to 10
This holiday in our bench, general bench.
by speed post with AD.
It's start from.
You can submit by Dasti also through your,
Yes, my lord.
Uh,
We'll post it by registered post.
you,
It's okay.
by speed post with AD.
It's holiday.
The learned CEC is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, list on
28 July
So 2/8.
to 8.
Yes.
Item number 20.
May it please, Your Lordship. Your Lordship, in this case, this honorable court has exercised the power under section 391 for recording additional evidence.
May I please, Lordship? Lordship, I beg to mention item number 10.
item number 10. Yes.
Lordship, actually, they have filed affidavit. So today itself, I received that copy. So I need some more time to go through this. So kindly, Madam,
Both sides are represented. The land counsel for the petitioner seeks some time to take instructions on the affidavit in opposition filed by the state, which was served on him today. So matters stands adjourned today. List after
Lordship, after 2 weeks,
2 weeks.
highly obliged.
Matters, my lord. I beg to mention item number 5. My lord,
Five.
5 years, my lord. I put a petition, my lord, with the consent of the other party. My lord, the kindly matter may be taken up after 2 weeks.
Okay, with consent of the other side, the learned counsel of the petitioner prays for adjournment. Prayer is allowed.
My lord, in the meantime, I will file our reply.
With consent of the other side, the learned counsel to the petitioner prays for time to file affidavit in reply in the matter.
Yes, sir.
Okay. Matter is adjourned today, list after 2 weeks.
I'd like to take action, item number 3. The counsel for the private respondent is having some health difficulties, so it's his action.
My lord, I am for the petitioner.
Who is absent, you said?
Conducting counsel.
Conducting counsel for the private respondent.
Okay. Both sides are represented.
And there is interim, which may be continued.
On the ground that the learned counsel for the private respondent is out of station. On the matter stands adjourned today. Interim order passed release stands extended till the next date of listing. List after 2 weeks. Okay.
Much obliged.
Your Lordship, I beg to mention item number 8. Your Lordship, this matter, the pleadings are completed. Kindly this matter may be fixed for admission.
Pardon me, when do you want?
Your Lordship, kindly this matter may be fixed on 24 June.
Okay, you are for the petitioner?
Yes, Your Lordship. Acting we have Deepagi.
You're taking consent of the other side?
Yes.
You're there, okay. All sides are represented. On the prayer made by learned counsel for the petitioner, list on 24/6/2026. Okay. Yes,
Lordship, with the consent of other party, I beg to mention item number 2, Lordship.
2.
Yes, Lord.
Okay, you are for?
I'm for private respondent number 4, on behalf of N. Khatwala.
Okay, with consent of the other side, the learned counsel for the private respondent prays for adjournment. Matter is adjourned today, list on.
Lordship, after 2 weeks.
It's a 2022 matter. Give a date after 2 weeks. We'll fix it after 2 weeks.
24 June.
Okay.
Or Lordship, this matter will be fixed after vacation, Lordship.
So that will be too long. It's a 2022 matter. Can't give a very long adjournment.
Lordship, I beg to mention item number 9.
9.
Yes, 9.
Yes.
Also for the official respondent for the people's okay. She is having the problem.
Okay, you're taking consent of the other side?
Yes. Okay. Kindly give it after 1 week.
Consent of the other side, learned government advocate pays for adjournment. Prayer is allowed. List in the next week. Okay. Give it date.
17 June. Item number 1.
May it please, Lordship.
Where is the order?
My lord, page 70 is the order, my lord.
70.
70, my lord. And lordship will page 72, paragraph 2.7 is the, my lord, operating part regarding delay, my lord. My lord, page 17.
And where is the assessment order?
Lordship will find it page 27, my lord.
27. But then your sole ground to
My lord.
challenge it
My lord.
will not have a ground because you see in this this assessment order,
My lord.
you are stated to have acquired your income
My lord.
not only from the government of Arunachal Pradesh but Meghalaya also.
My lord.
So therefore, you don't get the benefit of your being a indigenous resident here. Your income is derived from outside the state.
My lord, here what happened, my lord? They call for an explanation for providing 21 lakhs in note, my lord, purchases. They are not disputed. Meghalaya is also exempted from levy of income tax. It falls on the schedule 10, my lord. So regarding my status, there is no dispute. The dispute was that, my lord, I could not furnish details around, my lord, 5 crore 91 lakhs, my lord. Thereafter, I preferred an appeal, my lord, furnishing all the details. But instead of hearing the appeal on merit, my lord, was dismissed on the delay, my lord, appeal. My limited phrase, my appeal may be heard on merit, my lord. Appeal commissioner also sought all the documents on merit and I furnished all the documents, my lord. I'm not paying for any adjudication on merit, my lord. Here, my lord. Let my appeal may be heard on merit, my lord. There was a delay of around 172 days, my lord.
You are accepting notice for this Union of India?
No, but I'm for the income tax.
Okay.
I'm relying on judgment of Honorable Apex Court, my lord, regarding it was also income tax.
Notice, let them respond to it. That means you're appearing for all the 5 respondents.
No, no, 2 to 5.
Not for one. Who is the CGC here? You'll be appearing
Yes, Lordship.
on behalf of Mr. Kato?
Yes, Lordship.
Heard Mr. R.S. Mishral and counsel for the applicant. Also heard Miss Y. Gao, learned counsel appearing on behalf of Mr. M. Kato, learned DSGI for the respondent number 1 and Mr.
JP Mode, Lordship.
A.
JP Mode.
AP Mode, learned
JP Mode, Lordship.
JP Mode.
On behalf of Mr. S. Chetia, Senior Standing Counsel Income Tax.
Okay, appearing on behalf of Mr. S. Setia, Senior Standing Counsel for the Income Tax Department, representing respondent numbers 2 to 5. Issue notice on this app. This application and filed under Article 226 of the Constitution of India, by which the petitioner has assailed the This will be called order in appeal.
My lord, it is simply order, my lord. Order under section 250, my lord.
Achha, speaking order under section 250 of the Income Tax Act 1961, by which the appellate authority, no, say the Commissioner of Income Tax within bracket appeals, Income Tax Department, had refused to condone the delay of 172 days beyond the period of limitation in filing the appeal. Next. Requisite extra copies of the petition with enclosures be provided to the learned appearing counsel. Next para, list on how much time? Your date for the list of.
Can it be 22?
1st July.
My lord?
1st July.
1st July. Deeply obliged, my lord.
Item number 4.
Nobody is appearing for the petitioner. None appears on call for the petitioner. However, the respondents are represented. Forensic Justice, the matter stands adjourned today. List on, make it next Monday.
Yes, Monday. 15 June. Item number 6.
This case, there was 2 road projects. So I'm told that one of the projects is already completed and one is on the verge of completion. So I'll need to take written instruction from the authorities. So he had challenged the tender process. There was no stay order.
No, but you see, there is a difficulty here. In this case, on 29/1/2024, there was a statement made by you, which is recorded, that he assures the court that no final decision would be taken in the matter till the next date fixed.
No, before this order, already the decision was there. Before this order, I think.
But you have not filed any affidavit.
This affidavit,
Have you filed?
No.
Then that will not do. You see, if you're not vigilant, your matters would become infructuous. There is, for more than 2 years, the service on respondent number 8 and 9 is still not complete. So Mr. Tarak says that the work is already on verge of completion. By the time you serve, when they brought on record the settlement of contract on 17/1, nothing would survive here. The petitioner and the RWD within bracket respondent numbers 1 to 6, 1 to 7 are represented. Next para. It is noticed that notice to respondent numbers 7 and 8 were issued by registered post with AD as per office note dated 7/5/2024. So since then, neither the AD card nor the unanswered postal article has been returned back. Next, accordingly, the petitioner shall take fresh steps for service of notice on respondent number 8 and 9 by speed post with AD. The notice is made returnable on so and so. Give a date after 4 weeks. Returnable on so and so. Post of the learned counsel for the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next para. On the next date of listing, Mr. G. Tarak, standing counsel for the RWD, shall produce the updated instructions regarding the status of construction. List on so and so.
Of July. Item number 7.
Yes.
In this case, I'm appealing to respondent number 2, 3, 4, and 4, the oil company. We filed our affidavit in opposition long time ago.
My lord, pleadings have been completed, so matter may fix for admission hearing, ma'am. Since we are not filing rejoinder, ma'am.
But then you have no case at all. On merit, you have no case at all.
My lord, since my lord, the leading counsel is not today appearing to us, so matter may fix for admission hearing, my lord.
Okay, both sides are represented on the ground that the council holding the brief for the petitioner is not available. The matter stands adjourned today. List on
29 June.
29 June, we are not hearing any matter. It's just close to vacation. It goes to after, after 20 July.
Then my lord, in that case, my lord, August 10, my lord. 10 August, my lord.
10th August.
Yes, my lord. Because July, it will be holiday, my lord. Vacation, my lord.
No, July will only be vacation till 17th.
18th.
31st of July.
We'll make it 29th.
Because Mr. Saha, who is conducting this case, he comes from Guwahati. He is instructed me to make a request for 31st of July.
Yeah, we can take it on Monday. If because 31st will not be conducive. You can have it on 31st. No, sorry, no, not 31st. It's then goes to 3rd of August. Either 3rd of August or
But he is requested me for 2 dates, 31st of July or 10th of August. If it is not put, it will be.
you can make it 10th of August.